Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on Senate bills, actually on an amendment to a Senate bill referred to this committee with the potential for executive sessions to be held throughout. We will be holding an executive session on Senate Bill 96 immediately following the hearing today. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Clerk website. Notice for this meeting complies with House rules and with RSA 91A, right to know law. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. We do have one staff member who is listening in with us today, and that is our committee researcher, Jen Ford. Please note that all votes that will be taken during this meeting will be done by roll call vote. And we're going to begin our meeting by taking roll call attendance. When each member states their presence, please also state whether there's anyone in the room with you during this meeting, which is required pursuant to the right to know law. Mr. Clerk, would you call the roll?
Thank you, Mr. Chairman. Representative Alexander.
I'm here in the committee room.
Representative Burke.
I'm here in Westmoreland alone.
Representative Chase.
Representative Chase is not here. There are substitutes, and I believe Chair Gordon knows. We're missing two people, Representative Chase and Representative Macbeth, and Representative Catherine Rogers and Representative Lucius Parshall are the substitutes.
I should have mentioned that at the beginning of the meeting, that we do have 4 substitutes here today, and we should welcome Representative Melvin, who's filling in for Representative Rice, Representative Rogers, who's filling in for Representative Chase, Representative Renzullo, who is filling in for Representative Notter, and Representative Parshall, who is filling in for Representative Macbeth.
And if I could just make a correction there, it's partial. Thank you so much.
Thank you, Mr. Parshall.
How do you spell partial?
P-A-R-S-H-A-L-L.
Okay, where are we at? Representative Rogers.
I'm here in Concord. I'm alone in my apartment.
Representative Lorenzo.
I'm here in my home office in Newmarket, and I'm alone.
Representative Gordon.
I'm here in the committee room with my colleagues.
Representative Green.
I'm here in the committee room.
Representative Horrigan.
I'm here at home in Durham by myself.
Representative Kelly.
I'm here in Temple by myself at the moment, and I'd like to point out that it doesn't look like Representative Rogers is alone.
Representative Kenny.
Good morning. I am here in Durham, currently alone. Roommates may be throughout the room throughout the day. Thank you.
Representative Langley.
Good morning. I'm here in Manchester and my husband is around.
Representative Parshall. No, you're here.
Yes, I am here. Thank you so much. I'm alone in my room.
Representative McLean.
I'm here in the committee room at the LOB.
Representative Page.
Good morning. I'm in Exeter alone in my home.
Representative Melvin.
Here in the LOB.
Representative Murner.
Here in committee room.
Representative Simpson.
Hello, I'm here in Exeter alone at the moment. My spouse and sons may be through the room at some point.
Representative Smith.
Good morning. I'm alone in Durham.
Representative Renzullo. Here. Representative Chartier.
Here in the committee room.
Representative Buffer is here in the committee room. Representative Sylvia? You're not, you don't need to.
I've been booted from the committee already.
Representative Sylvia,
Here,
thank you.
in the room.
We have a full committee.
Thank you. We have a full committee in attendance. We're here this morning to hear a non-germane amendment. This is Amendment 2021-1244H, an amendment offered by Representative Birch. I would note that prior to the hearing, I received notice that 26 people registered in support of this amendment. 1,178 registered in opposition, and 6 registered as neutral. There are 8 people who have registered, pre-registered to testify. Of those people, 3 have registered to testify in support, 11 people registered in opposition, and 4 people registered as neutral. I note that most people registered to speak for approximately 3 minutes. There are a couple of people who registered for 5, but I expect that we should be able to get through our hearing relatively quickly this morning. And what we'll do is we'll call upon those people first who pre-registered. If other people have gone online and wish to testify, we'll have them raise their hands at the end of the pre-registered people, and they'll have the opportunity to testify if they wish to do so. And with that, I'm going to call upon Representative Birch first, if he would like to introduce or speak to his amendment.
Thank you, Mr. Chair. Just as a matter of procedure, do we already have a motion on the floor as to SB 96 overall so that I can introduce an amendment? I don't remember from last time we met.
Well, it's a hearing on the motion. If you would like to make a motion to accept that, I think that would be fine, and then we can act on that.
All right, just for procedural reasons, I would move OTP on SB 96.
It happens in seconds. Yes. Okay, I'm told that I'm all messed up, and that the amendment should be offered in executive session. So if that's the case, you can just testify to your amendment.
All right. So I don't need to formally introduce it at this point. I see a no from the clerk, so I will proceed. And colleagues, it's good to be speaking with you again in favor of this proposed legislation. I'll try not to be too repetitive of earlier testimony, and you'll have the opportunity to hear from some recognized experts on this issue. This legislation guarantees the citizens of our state have a right to go to state court for redress of harms done to them by the government. This legislation is not as complicated as some would make it. An activist Supreme Court tried an experiment in 1982 to provide qualified immunity to protect some government actors. This experiment has been widely considered a failure, and now the US Congress and many states are seeking to end this failure. This proposed legislation does 3 things. By eliminating qualified immunity, it returns the law to how it was in 1982, pre-1982. It provides a path to state court in addition to a currently existing route to federal court. And it shifts the burden of any financial penalty and costs from the individual bad actor to his or her government employer. In addition to some technical changes of language, the amendment makes some changes and clarifies some important aspects from HB 111 by putting some things into statute. It is made explicit in this amendment that state, county, and municipal employees who are acting in a judicial or legislative capacity, select board members, aldermen, commission members, and the like, will keep their immunity from suit in their personal capacity, as they always have had. It is made explicit in this legislation that the acts of state employees are to be examined in the light of what a reasonable state employee should have done given all the circumstances existing at the time the action was taken. The employee must act reasonably. The determination of reasonableness must embody allowance for the fact that employees are sometimes forced to make judgments in circumstances that are unclear about what is necessary in a particular situation. And finally, the amendment removes the alleged bad actor from lawsuits, clarifies and makes certain that the individual actor is not to be held financially liable. Why is this legislation necessary? When police wrecked a woman's home by bombarding it with tear gas grenades after she agreed to let them in to arrest her former boyfriend, no civil liability due to qualified immunity. When a sheriff who shot a 10-year-old boy while trying to kill his dog, no qualified immunity. When a sheriff responding to an erroneous domestic assault report grabbed the purported victim in a bear hug, threw her to the ground and broke her collarbone, no civil liability due to qualified immunity. When police officers stole cash and property worth $225,000 while executing a search warrant, no civil liability due to qualified immunity. Then there's the question of the Sununu Youth Center, where hundreds of claims have been made of sexual and other abuse of children by state employees. If that in fact did happen, should those abusers and their employer be protected from civil suit by their victims because of qualified immunity? Let's clear up a few misconceptions. This legislation has nothing to do with frivolous lawsuits. The courts have and will continue to have plenty of power to dismiss frivolous suits and impose sanctions, financial and otherwise, on those who file them. Studies in Colorado and California debunk the claim that municipal costs will increase to any significant degree with this type of legislation. If there are costs, that is due solely to the misconduct by state actors, not legislation. It helps at time to return to basic principles. The first is something every person here probably subscribes to. The citizen is in a higher position than the government. The government works for the citizen, not the other way around. This is a bedrock conservative principle, a bedrock libertarian principle, and a bedrock liberal principle. Basic principle number 2, when the government harms a citizen, the government then cannot decide the citizen has no redress, that the citizen is out of luck, that the government gives itself immunity from the citizen. Our founders in New Hampshire had it exactly right in 1784 when they wrote Part 1, Article 14 of our Constitution. Legal remedies to be free, complete, and prompt. Every subject of this state is entitled to a certain remedy by having recourse to the laws for all injuries he may receive in his person, property, or character. And it goes on from there. I have no quarrel with those who have focused on the potential liability of county and local and state entities who employ or continue to employ people who violate constitutional rights of citizens. Our county executive committee does our budget in Cheshire County. I have served on it for 9 years. I'm currently chair. I know much of what there is to know about county budgets. And I know 2 things. This legislation will not cost local governments money. Bad behaving employees will cost local entities money. If you want to avoid these costs, hire well, train well. We self-insure in Cheshire County, and we put our focus on hiring and training well. I also have no quarrel with either the lobbyist for the municipalities, a thoughtful and by the way, very nice person, nor with lobbyists for police unions. I support unions and what they do for their members. But their job is to look after the narrow interests of their particular clients and to direct your attention specifically to the interests of their employers, a slice of the pie, as it were. Their job is not to look after the public interest. That's our job. As many of you know, I was a career public defender. My job basically was to get my clients off with the leastest, consistent with the rules and ethical guidelines. It's not my job to look out for the public interest. That was the job of others. Similarly, the job of lobbyists for the police and municipalities is not to look out for the public interest, just to get their clients off, so to speak, with the leastest. That's honorable. That's not the job of this committee or the legislature. We need to look at the whole pie, not just a slice. And I think it's inescapable that the qualified immunity is a failed experiment, not in the public interest. I do have a bit of a quarrel with what I received yesterday from the lobbyist for the New Hampshire Municipal Association. And I assume the committee received the same letter. In it, the claim was made that if this amendment were passed, litigation and insurance costs will rise, municipalities will have even more trouble recruiting employees, individuals will be reluctant to serve in town government, there will be absolutely no positive effects on the behavior of municipal employees or officials. Frankly, this is virtually word for word what we heard from the same folks several years ago when we considered removing standing or changing the laws of standing to allow taxpayers to sue in our state, something that was approved by this committee, approved by the House and Senate, and approved by the public. And guess what? We were told that litigation and insurance costs would rise. Nope, didn't happen. Municipalities will have trouble recruiting employees. Nope, didn't happen. Individuals will be reluctant to serve in town government. Nope, didn't happen. And there'll be no positive effects on the behavior of municipal employees. Now, basically, very few things were brought. I want to respond specifically to the last claim. Absolutely no positive effects on the behavior of municipal employees. I'm saddened to read that claim because I also read a very short time ago that the world's largest municipal police union, the Police Benevolent Association for New York City, wrote to its members after New York City recently passed qualified immunity. And they told their members that they strongly caution police officers to limit their searches of individuals or private property to cases where the officers clearly and unequivocally within the bounds of the law. They went on to some detail saying, now that we don't have qualified immunity, you got to really be sure that you're operating within the strictures of the law. Well, I congratulate the New York Police Benevolent Association. And I believe that approach is good police work and it's good for the community. And I reject the claim that no positive effects will occur on behavior of municipal employees or officials. Finally, we know that citizens are being harmed by bad acting government employees. And these employees in the government agency that hired them are far too often walking away scot-free because of a judicially invented immunity. That offends not only the New Hampshire Constitution, but offends on who we are as granite staters. The doors to our courts must be kept open to redress wrongs done to our citizens. That's what this legislation will accomplish. Thank you.
Thank you. Are there any questions for Representative Birch? Yes, Representative Trotter.
Good morning, Representative Birch. Thank you for taking my question. You named off some scenarios this morning. One was where a young boy was shot by the police over the dog, a tear gas incident in a home, and also about $250,000 being stolen during a search warrant. Were these New Hampshire cases or were these cases in other states?
As far as I know, those were cases in other states. There are, and thank you for your question. There are two further comments on that. One, there are cases, especially with excessive use of force, that occur and are being litigated to some extent because it's hard to litigate in New Hampshire. And prior events, former Justice Douglas has made reference to a couple of cases that he's actively involved in right now, which I think involve the at least one, the Nashua Police Department. The difficulty is that with immunity, you don't know how many of these cases exist, because let's say I am harmed by, or believe I am harmed by the action, improper action of a police officer who violated, let's say, my constitutional rights. I go to a lawyer and the lawyer says, it's not worth the time and effort to bring the suit because it's going to get thrown out on qualified immunity. So I go away and there's no record of it. There's no way of quantifying how many of those cases exist, but they do exist. Some of them are being litigated.
Well, Representative Trotter.
A follow-up question, Mr. Birch. Representative Birch, sorry about that. Doesn't New Hampshire have a process to investigate allegations against police officers, including use of force already?
No.
That they may, and there's certainly an open question about how effective that is and how effective it isn't, but that's a different issue than whether a victim in a case, in a situation, has a right to go to court and ask for redress of their harms. A process may find that the officer acted correctly or incorrectly or whatever. That may be, and criminal charges may be brought or may not be brought. This legislation has to do with the right of you or me to go to court and say, a government actor violated my constitutional rights, harmed me, and I want justice.
Thank you.
Representative Kelly, I saw your hand up. Do you have a question?
I did, but it was answered. Thank you.
Are there any other questions for Representative Birch? Seeing none, thank you for your testimony today.
You're welcome.
Start with our list of people who pre-registered. The first one would be Representative Lynn, if he's there. Representative Lynn, if you could raise your hand. Yes, there he is.
Hi, can you hear me?
We can.
Oh, thank you very much, Mr. Chairman and members of the committee. I have several points I'd like to make, and I'll try to be as brief as possible.
Thank you.
First of all, I would say it just initially, although this bill has been referred, this amendment has been referred to as an amendment that eliminates qualified immunity. The term qualified immunity comes primarily from federal case law. As far as I know, in the state of New Hampshire, under our case law, I don't believe that there's a case that uses the term qualified immunity. Rather, we refer to statutory immunity or common law official immunity. And I point that out simply because to avoid any confusion, I think the concepts are basically the same, but terminology sometimes can be important. The first point that I would make is that it's important for the committee to understand that this bill does not simply eliminate qualified immunity or official immunity, whatever you want to call it. It also creates a constitutional cause of action under state law to allow the recovery of damages. And I would suggest that there is no need for the creation of such a cause of action. I would ask the committee to contrast this with, I think the argument has been made that this is really creating the state law equivalent of a federal cause of action, similar to the one authorized under Section 1983 of Title 42 of the US Code. The problem is there was a reason for having Section 1983 to allow a constitutional cause of action under the federal Constitution, because there is no body of federal tort law. Federal tort law, as a practical matter, doesn't exist. But in New Hampshire, we have a well-developed body of state tort law. And in fact, anything as a practical matter, anything that could be characterized as a violation of state constitutional law, I can't frankly think of an exception, and I would invite somebody to offer one. But anything that would be a violation of state constitutional law would also constitute a common law tort in New Hampshire, such as the tort of assault for unlawful use of force or excessive use of force, or battery, or false imprisonment, or malicious prosecution, or trespass if, for example, the police executed a search warrant without probable cause, or invasion of privacy, or interference with contractual relations, etc. There is no reason to create a new constitutional tort when conduct that is wrongful can be remedied under state common law. This bill also purports to allow a claim for equitable relief. But equitable relief, qualified immunity, has not been. It certainly is not a defense where a litigant is seeking equitable relief to prevent future misconduct. So that's, again, the qualified immunity just would have no application there. Now, to the one thing about this, the one part of this bill that I think probably I would agree is a good idea is to allow attorney's fees to be claimed in cases where there's a claim of the type that would involve police misconduct. So I guess the question I would have is, why create this new constitutional cause of action when there's no necessity for it, and when it invites the opportunity for just sort of creating confusion? So good lawyers will argue that, oh, well, assault and battery may prohibit this, but now this is a constitutional claim. There's some nuance that's different. Let's create a new body of law. Why do that when there's really no need for that to be done? The common law provides perfectly adequate remedies. The second point I would make is that this amendment may be unconstitutional to the extent that it seeks to eliminate the naming of individual officers as defendants in suits based on federal law, or to the extent that it eliminates qualified immunity for defendants in Section 1983 actions. And if you read the bill, it purports to, this cause of action that it creates is one that would apply for violations of the United States Constitution also. Although the US Supreme Court has held that Section 1983 actions can be brought in state court, I firmly believe that the state cannot change substantive federal law. So that, for example, if the suit is based on a violation of the federal Constitution, I don't think the state would have the authority to eliminate qualified immunity. Only the federal courts could do that. And the same thing would apply to eliminating, removing individual officers as defendants. If the suit was brought under federal law, I don't think the state could do that. The third point, and I think this is very important, is that this amendment goes further than HB 111 did in at least one important respect. in that it purports to eliminate immunity, not just for causes of action where the law was not clearly established at the time of the police action, but also for cases where the officer acted reasonably at the time in question. And I refer you specifically to proposed RSA 507H4 1A, the second clause, and RSA 507H4 1B. I think this is very problematic because reasonableness is itself often the standard for determining whether police action is constitutional or unconstitutional. For example, police are allowed to make a stop if they have reasonable suspicion that a crime is about to be committed, or may conduct a search without a warrant if they reasonably believe exigent circumstances exist. Does this amendment's language that, quote, the court shall not be impeded by an invocation of a state agent's defense or immunity, close quote, as proposed in RSA 507H41, where such immunity is based on the reasonableness of the officer's conduct, mean that reasonableness is no longer to be considered in assessing whether the conduct was unconstitutional in the first place? I assume that that was not what the drafters intended, but that is a real problem in terms of what does reasonableness mean? Why is the reasonableness different here than reasonableness in terms of what the constitutional right is in the first place? Eliminating suits against officers personally by providing that only the state or municipality will be named as a defendant does not solve the problem of inhibiting officers from properly doing their jobs. First, I should point out that this amendment would eliminate personal liability even when an officer clearly was acting unlawfully. And my question would be, why would you want to do that? If an officer clearly was violating the law, why shouldn't they be held personally liable? I would certainly think they should be. Second, imposing liability on the governmental unit does not resolve the problem, because if the municipality is to be held liable for officers' actions that were not clearly wrong when they occurred, such governmental units will encourage their officers to be reticent to do their jobs when there is a chance that the state or the town could be sued. The watchword for officers from their political leaders, the mayors, governors, whatever, will become look away. Don't be curious. Don't pursue suspicious activity in any situation where your actions might be called into question later and state or municipality be held liable. And the officers will listen, particularly since this amendment specifically says that if the state or local government is found liable for a constitutional violation, even if the officer acted reasonably, the officer can be terminated from his job, notwithstanding, for example, any protections that might be offered by a collective bargaining agreement. And for that, I refer you specifically to section H61 of this proposed amendment. As can be seen from rising crime rates around the country.
And I don't want to cut you short, but if you could sort of wrap up, that would be great.
Sure. As arising from.
Ask for 5 minutes and we've gone about 10. So
I'm sorry. All right. As I think can be seen from rising crime rates resulting from things like defund the police movement and other anti-police rhetoric, police will be encouraged to adopt a hunker down mentality if this amendment were to be adopted. So I would suggest first that this amendment should not be adopted, and that this matter should be studied over the summer and perhaps brought back in a more comprehensive way in the fall. But so I would say just don't do anything, kill the amendment and don't do anything. But if the committee feels that there's a need to do something, I've sent committee members a proposal that I think solves the specific problem of where qualified immunity has been applied improperly by some courts without eliminating qualified immunity. And so as a fallback position, I would urge the committee to consider that amendment. Thank you very much. I'm happy to answer any questions.
Thank you. Representative Smith, did you have a question?
Yes, I do, Mr. Chairman. Thank you very much. Representative Lynn, are you saying that the police in the state of New Hampshire make their decisions about how to act in certain circumstances, based on whether it would be better to, I think in your words, hunker down than to follow both the law and their ethical responsibilities as public employees?
I'm sure, I'm saying that that certainly is a consideration. I think we've seen that kind of thing happen around the country. I mean, New York City is a perfect example. The police have, the message that's gone out is just back off, look away. Because if you don't, if there's any kind of chance that you might, that you're going to end up being sued, that's the safer course. And unfortunately, I think that there are a number of officers who will decide that's the reasonable choice to be made, and we shouldn't be encouraging that.
Could I just follow up quickly? I know that Representative Lynn has taken a lot of time, and I don't want to exacerbate the situation. But are you also saying, Representative Lynn, that those people with the responsibility of hiring public officials, therefore should not exercise the most rigorous investigation in terms of hiring and in terms of training and in terms of supervising and in terms of holding people accountable, because it would be better just to let anybody in and then let them do what they want to do?
I'm not saying that at all. I'm not suggesting that in the slightest. I think it's absolutely important that police officers be, trained very, very well and that they be held accountable. I have no question about that whatsoever.
Thank you.
Any other questions for Representative Lynn? Seeing none, thank you for your testimony today.
Thank you.
Ross Conley.
Thank you, Mr. Chairman. Can you hear me?
You can.
Excellent. Well, thank you, Mr. Chairman and members of the committee for holding this hearing today. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity in New Hampshire. And just to clear it up, we are in support of the amendment. We're neutral on SB 96 in totality. This amendment is quite straightforward. It makes changes to HB 111, as we've heard, and these changes address much of the feedback and concern we heard from the debate on HB 111. Specifically, it ensures the employee's name will not be listed on the suit, instead listing the government entity or employer. This amendment also makes clear that legislative immunity will still apply to all elected officials. This includes local elected officials who the courts have determined fall under the doctrine of legislative immunity, not qualified immunity. And these changes also do not apply to the judicial branch. This amendment will not have an effect on good government employees, but instead creates a remedy for the few bad actors in government who violate citizen rights. Currently, if a citizen's rights have been violated by a government agent, there are very few avenues for the citizen to hold the government accountable for the actions of the employee. This type of undermining of accountability leads to an erosion of trust between citizens and its government, particularly in law enforcement. Qualified immunity allows the few officers who do violate a person's rights from being held accountable, which makes a good officer's job much harder. We live in a constitutional republic. If our constitutional rights are being violated by the government, then that one bad actor in government breeds distrust across the entire population, as we have seen. And it's important to remember that qualified immunity only becomes relevant after it is determined that the government has violated a person's constitutional rights. Public officials, specifically law enforcement, is already given great deference on what is reasonable and what isn't. Objectively reasonable decisions are protected by the Constitution with or without qualified immunity. Qualified immunity is also completely antithetical to the spirit and founding principles of New Hampshire. It harkens back to the days of the divine right of kings, which was the idea that since kings are appointed by God, they could only be held accountable by God. New Hampshire was one of the first places on earth to challenge that idea. Ebenezer Mudgett, Josiah Bartlett, and John Stark stood up to the monarchy in defense of citizens' rights for a more accountable government for and by the people. Our entire structure of government was built upon accountability. That is why we have an executive council to provide a check on executive power of the governor. It is why we have one of the largest legislatures in the world. Government and its employees should not be above the law, and they should not be above accountability from the people they serve. We must restore this trust in our government, and reforming the doctrine of qualified immunity will go a long way towards doing just that. This amendment is simply about government accountability, transparency, and upholding our fundamental constitutional rights. And for these reasons, we urge the committee to approve this amendment to SB 96. And I'd be happy to take any questions.
Are there any questions for Mr. Connolly? Seeing none, thank you for your testimony today.
Thank you for your time.
Judy Milner. Ms. Milner, you may have to unmute.
Can't wait for the day that my equipment is not superior to me and I can use an unmute button. Thank you for that. I apologize, and I want to start again by saying good morning, honorable members of the House Judiciary Committee. Thank you for the opportunity to speak today. My name is Judy Milner, and I have the privilege of serving as the city manager for the city of Franklin. By the way, it's nice to see you again, Judge Gordon. I am speaking today regarding the amendment to Senate Bill 96 that closely mirrors House Bill 111, which in essence revokes municipal qualified immunity at every level, regardless of whether or not the employee was acting in good faith. There are many unintended consequences to this amendment that will eliminate the protections under qualified immunity. Earlier today, in earlier testimony, and in testimony from House Bill 111, many of you have heard testimony on topics such as the amendment is overarching, not just affecting the police department, as many think the attention of this legislation is, but affects all facets of municipal government, from administration to code enforcement, to building permits, to public works, recreation, school districts, and to our volunteer, not elected, boards and commissions. This amendment punishes the municipality for good and bad acting employees, and it may have further unintended consequences of having employees hesitate to act when they should. Other testimony was that this amendment would make it near impossible to replace our aging municipal workforce and increasingly empty chairs on our volunteer boards and commissions, as citizens would be fearful of the potential negative impact to the community of good faith decisions. Or in New Hampshire, unlike some other states, qualified immunity does not mean 100% protection or that employees are not accountable for their actions. Qualified immunity does not mean that municipal employees are not held responsible for reckless behavior, or that municipal employees are not subject to criminal prosecution or tort liability. Under current law, they are. Or that qualified immunity protects municipalities from lawsuits arising from good faith decisions. Not all lawsuits resulting from bad behaving employees are from bad behaving employees. Some are from public amenities, such as public parks, that are free of charge, that also benefit from the protections of qualified immunity. I agree with all this prior testimony, but what you may not know, and what I'd like to talk about today, is how this amendment would devastate a community like Franklin. It would put poor and small communities at a disadvantage and hinder those communities' ability to move forward economically. Let me explain. Franklin is a mill town We were once a thriving community, but after the last mills closed in the early 70s, we have steadily declined to a revenue-starved, property-poor community. Over the last 5 years, Franklin has pulled up its bootstraps and put in the work to reinvent ourselves in a sustainable way that will bring economic vitality back to our community, as well as those communities surrounding us. The results of those efforts are finally coming to fruition in 2021, as the construction of our whitewater kayak venue in the Winnipesaukee River will begin this summer. As many of you have probably heard in recent news articles, this whitewater kayak park is the first of its kind in New England, although there are over 300 parks in North America. It will bring a whole new outdoor recreation economy. Imagine the ski industry coming to New Hampshire for the first time. This outdoor recreation economy is based on evidence from the other 300 parks show that will bring over 160,000 visitors to watch those taking part in the activities in the river. Those visitors.
Ms. Milner, I don't want to cut you short. We appreciate what you're doing with the water park, but if you could just focus on the amendment, that would be appreciated.
Yeah, I'm getting to that. Thank you. So this outdoor park is going to be the anchor of our outdoor amenities, and it's going to be our revitalization effort to become an outdoor recreation destination. So we have several outdoor recreation events in the city. They're all free to the public. This amendment, taking away qualified immunity from those, makes it difficult for us to continue along that path of economic development. So qualified immunity allows us to provide these amenities, which will bring in our economic engine and bring vitality back to the community. Franklin simply could not afford any of this without qualified immunity. Although Franklin will take pride in keeping our amenities maintained and safe for the users, there is inherent risk in any outdoor recreation activity. Qualified immunity protects us from that risk. Our little community pays currently $165,000 per year for property liability insurance with qualified immunity in place. Recently, the city had all of our insurances, including our property liability insurance, out to quote to ensure the best rates for the citizens of Franklin. Franklin does not participate in the public pool for property liability, but does have a private insurance carrier. So all of the insurances came back with the exception of property liability. We were told that the potential elimination of qualified immunity was a big part of that. Bigger communities may be able to afford the increases in property liability or judgments imposed. Franklin and other communities like us simply cannot afford to maintain insurance coverage or afford damages from potential and likely frivolous lawsuits resulting from using our free to the public amenities that will drive our revitalization. Amenities that will no longer be viable because the risk may be too high will be things like the whitewater kayak park, our ski mountain, playgrounds, parks, ice skating rinks, trails, climbing walls, parkour courses, pump tracks, beaches, and pavilions, just to name a few. These are things.
You asked for 3 minutes, so I'm going to ask you to wrap up if you would.
I'm almost there. Thank you very much. So these are the things that this community that is redefining themselves as an outdoor recreation needs. This is Franklin's future. Qualified immunity is necessary to move forward with this economic development effort. This proposed amendment will strip Franklin and many other communities of the things that will make them communities and not a place to put your stuff. This proposed amendment will kill Franklin's best shot of economic recovery in the past 50 years and make the last 5 years of our efforts for naught. Please consider the unintended consequences of this amendment when voting on this amendment and give Franklin and other communities a chance to thrive. Thank you for your time and attention today.
And are there questions? Representative Smith, did you have a question?
Yes, thank you very much, Mr. Chair. And I hope you can answer this very briefly, Ms. Milner. But are you saying that Franklin is planning to do things that are not responsible in terms of protecting the best interests of the city and of the public, and therefore you want to be free of any responsibility for what you do?
No, Franklin is committed to maintaining the best possible parks, all of our free amenities, and keeping them safe for the
Thank you
public.
very much for that answer.
Yeah.
Then I don't really see the relationship between this proposed amendment and your testimony, but I do not. I respect the committee's time and therefore hope that we could talk about it on another occasion so we can explore those views. Thank you.
Thank you. I do have an example if you'd like to talk about it.
Not right now, because I think we try to make sure we hear from as many people as possible. I'm sure you understand that.
Absolutely. Thank you.
Representative Horgan, did you have a question?
Well, yes, sure. Yes. First of all, Ms. Milner, I hope whoever there's a shooting incident in Franklin, so I hope the gunman is found soon and the situation resolved. But how is your situation as a municipality that's developing a whitewater kayaking thing or any other attraction of that sort? How are you different from a private entrepreneur? If a private company wanted to start one, they would probably take it for granted that they would need that they could be sued if somebody was seriously injured if they were involved.
Right. So unlike a private entrepreneur who would charge a fee and pay their liability insurance out of that fee, the city of Franklin is providing these amenities free of charge to the community. So so it makes it a little bit different than a private person where you could, if you go to a ski mountain, you are paying for that lift ticket for sure. But in Franklin's ski mountain is a community ski mountain and there's little to no fee to use it.
Okay, so what? Oh, okay, I'm just wondering what's sort of the financial plan for it if there's no fees? So how is this being paid for?
Right. Right. So our community, like I said, bootstraps. We do a lot of fundraising in the community in order to provide these amenities. Many of our children, 60%, are free to reduce lunch in our school district. So we'd like to provide these amenities to give them something better to do with their time. So that's what we do in Franklin.
All right. Thank you.
Mm-hmm.
Thank you for your testimony today, Ms. Milner.
Thank you.
And next person would be Keith Neely.
Thank you, Mr. Chair.
Mr. Neely, you asked for 5 minutes. I'm going to hold you to that, okay?
Yes, sir. I will be as swift as possible. My name is Keith Neely. I'm an attorney at the Institute for Justice. IJ is a nonprofit law firm that works all over the country to defend individual rights. And I wanted to testify today in support of Amendment 1244H to Senate Bill 96 because it represents the gold standard for state civil rights reform. And it's an excellent opportunity for New Hampshire to continue leading the country in protecting individual liberties. Today, I wanted to make just 3 very swift points. The first is that it's important that municipalities are held responsible for the bad actions of their employees because that's the very same standard that we apply every day in the private sector, because we as a society recognize that employers have a responsibility to hire better, to train better, and to supervise their employees, and municipalities are no different. Representative Lynn earlier made a comment that perhaps it would be best to hold officers individually liable. But one of the problems with that approach is that it leaves the victims of government misconduct to the whims of the officer's bank account. And when victims are faced with a constitutional violation and they go after a judgment-proof officer, an officer who cannot pay for the violations that they committed, then the victim is left without an effective remedy. And that's why municipalities need to be on the hook for the bad actions of their employees. The second point I want to make is to echo what Representative Birch said in his opening remarks, which is that the costs of ending qualified immunity are not inherent to this legislation. They're inherent to the bad actors in the system. But I want to make one further point, and that's the fact that these costs already exist. The problem is that they're being borne by the victims of government misconduct. They're being borne by people all over the state of New Hampshire who currently don't have a remedy when their rights, have been violated. And so what this legislation does is it reapportions those costs. It doesn't create them. It reapportions them to the organizations and entities within the state that are responsible for them. Lastly, I wanted to respond to a couple of the earlier comments that were made, first by Representative Lynn about reasonableness. And with respect to Representative Lynn, I think he misreads the plain text of this law when he directs the committee to 507H4 subpart 1A, because that discussion of reasonableness in the statute pretty clearly refers to an officer's subjective understanding of his activity. And what I mean by that is that under this amended law, the fact that an officer subjectively believed that what he was doing was okay is no defense, because his objective standard, as the Supreme Court has frequently held in a variety of cases, is all that matters. And so his concern that somehow this invocation, or excuse me, this bar of reasonableness would lead to all kinds of a parade of horribles is frankly unfounded. And lastly, I wanted to respond to some of the comments from the previous speaker about the Franklin Water Park, because, respectfully, I think she misunderstands the role of qualified immunity, because qualified immunity has nothing to do with negligent slip and fall cases of the type that you might expect to see in a public utility like a water park. It has to do with the deprivation of constitutional rights. And with respect to the previous speaker, I do not know many water parks whose business models are built on the wanton deprivation of constitutional rights. And if there are any, I certainly would not want to attend such a water park. So with all that said, I respectfully urge the committee to vote in favor of Amendment 1244H, and I am happy to answer any questions.
Thank you, Mr. Neely. Representative Alexander, do you have a question?
I do, Mr. Chair. Thank you. Thank you, Mr. Neely, for taking my question. Your last example about the water park, how there's no deprivation of constitutional right. Are you aware of in the amendment there is also a violation of law gives warrant for a lawsuit or a cause of action as well. So it's not just constitutional right.
Well, it's the rights, privileges, or immunities secured by those laws. So I would respectfully respond that it's not simply a deprivation of a law, it's a deprivation of a law that creates an individual right. And in prior cases, and really throughout this nation's entire jurisprudence, right, there's been a distinction between simply a violation of a law and a violation of a law that was intended to create an individual right. So again, I don't believe that even as this law is currently written, you would see slip and fall cases become a constitutional tort. That's not what the language, as I understand it, that's not what the language of this amendment would do.
Are there any other questions for Mr. Neely? Mr. Chair. Yes, Representative Trotter.
I have one quick question. Thank you, Mr. Chair. Attorney Neely, you said you represent plaintiffs around the country. Do you currently, or have you been contacted by anybody from the state of New Hampshire to represent them in any of these type of cases?
No, sir, I have not.
Any other questions for Mr. Neely? Thank you for your testimony today.
Thank you, Mr. Chair.
Kyle Aspinwall. If you're there, can you raise your hand, Mr. Aspinwall? Don't see him. Ani Malika.
Good morning. Can I be heard, sir?
You may.
Excellent. Thank you very, very much. Good morning, and thank you, Chairman Gordon, and to the members of the House Judiciary Committee for allowing me to provide testimony relative to Amendment 1244-H for SB 96. And just a quick moment of housekeeping. I got a little confused in terms of signing up for testimony this morning. I show opposition, which I am in opposition, as I'll get to, for the amendment, but not for SB 96, the bill. So I hope that that's clear.
We're just at our hearing this morning. We are just addressing the amendment.
Excellent. Okay, very good. Thank you.
You did ask for 5 minutes.
Yes, I did. And thank you very much. So speaking plainly and from the heart and as eloquently as I can muster at this hour of the morning, I wanted to speak a little bit about the Lee Act members who put forth the original bill as we're moving towards through the conversation about the amendment. We formed a bit of a breakfast club. We had a general, a deputy general, a Department of Safety chair. We had standards and training providing information for what police officers should aspire to. We had a leader from the Council on Diversity and Inclusion. We had a president from the NAACP, one of the oldest civil rights organizations in the country. We had a justice of the court. We had rank and file police officers represented. We had the chiefs of police of New Hampshire represented. We had mental illness an organization represented. We had a smart justice organizer who is dedicated to justice reform. We had a public defender. We also had, at this point, he is now the Assistant Commissioner of Safety and one of the first African Americans put in that position in the history of New Hampshire, if I'm not mistaken. We also had another community organizer, and then there's me. My day job is the executive director for the Human Rights Commission, New Hampshire's oldest civil rights organization, and led by me, a third generation civil rights worker. These are our bona fides. And with all of that, we were courageous in our efforts to put feelings aside and look at facts from a myriad of perspectives. And you, legislators, must be courageous also. You show up for people and do the tough stuff. And as the resident thread puller, I have a question, several questions for you today. Is sliding language from a bill that was previously laid on the table courageous? Is the obfuscation of months of hard work and consensus building to create SB 96 courageous? And possibly killing this bill with a decidedly short-sighted attempt at vainglory, is that courageous? I would say not on this day. Now, I am very respectful of each of you and this legislative process, even though it can be very frustrating. However, I'm extremely disheartened at the repudiation etched into the language of Amendment 1244-H. I would also ask that this body, of which I include the sponsors of the amendment, are to vote ITL on said amendment and allow SB 96 to proceed forth. A conversation about the actual content of 1244-H can be had again, just not in this way, not with this bill, and not in this session. With that, I close my testimony and thank you all very much for being truly courageous in advance by helping all state employees, of which I am one, by voting this amendment ITL. I am very happy to answer any questions that may be had from the committee. Thank you.
Are there any questions for Ms. Malachi? Seeing none, thank you for your courageous testimony. And the next person to testify will be Brandon DePosa.
Yes, hi, this is Brandon Del Pozo. Can you hear me?
Yes, we can hear you.
Yes, thank you.
You did ask for 5 minutes.
Yeah, thank you. So thank you for having me. My name is Brandon Del Pozo. I am a postdoctoral fellow in substance use research at Brown University. What brings me to your proceedings today is I served 23 years as a police officer, 19 years in the New York City Police Department, and 4 years as the chief of police of Burlington, Vermont. I don't take coming to a state where I did not work as a police officer to offer testimony lightly, but I will say, by way of my interest and affinity for New Hampshire and what brought me here today, I attended college in New Hampshire. I lived in New Hampshire. I served in the New Hampshire Army National Guard as an infantry officer in your fabled mountain warfare unit. and I've hiked all of the 48 4,000 footers. So this is a state whose proceedings and laws and goings on matter very much to me. I'm testifying today in support of the amendment as a police officer and former chief of police for a handful of reasons that I'd like to offer some perspective on. The first is, as a retired chief of police, I'm currently named in 3 federal lawsuits. I'm dealing with them, and I will be dealing with them for the next 3 years. I don't find that to be an enjoyable situation. I find it to be stressful, but I do acknowledge that citizens have the recourse to bring suit. And I know that I am indemnified as having liability for the outcomes of those suits based on the fact that it was part and parcel with my official duties. Now, my brother, and this is relevant to qualified immunity, was an attorney. He's a former prosecutor for the New York County DA's office. He's also an employee of the New York State Attorney General. He filed an amicus brief on a very notable qualified immunity case, Tolan v. Cotton, that went to the United States Supreme Court in 2014. His amicus brief and his writings were cited in the court's decision, and it really had an effect, in my opinion, on qualified immunity. This was a case where Tolan was in a car he owned going to a house he lived in with his mother when an officer misentered the license plate, thought his car was stolen, and approached him in his own driveway with his brother and his mother, all of whom were unarmed, held him at gunpoint. And when the mother became indignant, saying, "This is my car, these are my sons, I live here, why are you pointing a gun at me? Nobody's armed," the officer went hands on with the mother. Tolan cursed and said, "Get the F off my mom," and rose up from the ground. He was shot. It ended his career in professional baseball. He was ascending to that. His father was a Major League Baseball player. It had a permanent effect on his health. And for him and his family to get any redress at all for being in their own driveway with their own car in front of their own home, unarmed, just going about their business, completely innocent of any wrongdoing whatsoever, because a police officer entered a license plate wrong, thought the worst, held them at gunpoint, ended up shooting one of them. For them to get any recourse, they had to take their case to the United States Supreme Court because of qualified immunity. And the idea that citizens have to take their case, in some cases, to the US Supreme Court to get any redress for egregious misconduct just struck me as wrong. And my brother's legal work in that regard, which I followed, changed my opinion on the breadth of qualified immunity. It is not necessarily a terrible idea, the idea that police should be immune from certain frivolous lawsuits. But the way case law has prevailed has made it overbroad and overreaching and foreclosed legitimate citizens' claims to get civil redress for substantial acts of police misconduct. And I remind, and one of the moving things when I was here last week, listening to the testimony before it was moved to this week, was to listen to New Hampshire police officers talk about their passion for their careers, their passion for public safety, the idea that they need to have some leeway to do their jobs well. I'm tremendously sympathetic to them. I have tremendous admiration for any police officer working in today's environment, and I have immense respect for the for New Hampshire law enforcement. And this is not to discredit them in any way. I do feel that municipalities that train well, hire well, hold their officers accountable for misconduct, set the right standards, will not feel an appreciable change between the situation that exists now for them and the situation that would exist if you were able to bring civil suit at the state level to get redress for police misconduct. So that having been said, thank you for this opportunity to speak, and I'd be happy to answer any questions.
Thank you. Are there any questions for Mr. DePozo? Yes, Representative Alexander.
Thank you, Mr. Chair, and thank you, Mr. DePozo, for taking my question. Can you describe a little bit more into the reasons why you left the Burlington Police Department?
So yeah, I left the Burlington Police Department because when the city council was a Democratic, so Bernie Sanders, for example, lives in Burlington. It's a very left-leaning city. Even as a very progressive police officer, I was seen by many people on the far left as some sort of right-leaning. So I was a cop. I could do no right. I had an excellent relationship with the community until the socialists took over the city council. When the Progressive Party, which is a socialist party, took over the city council, they decided to try to disarm my police officers, reduce the size of my police department. They said that 40% of my police officers were domestic abusers. And I reacted poorly to that. There was a city critic who I trolled on Twitter anonymously. I was frustrated by the way my cops in the city were being treated by the socialists among us. I took umbrage to that, and I did what many, 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 many citizens have done. I said anonymously, this is for example, the people who ignore you have antibodies that the rest of us should clone because it would be very valuable to not have to pay attention to a person like you. I said that on Twitter anonymously. And when the news found out, I first denied it. And then I said, I will tell the truth the next time I'm asked. I did. And there was a scandal that a chief of police used Twitter to criticize somebody anonymously. At that point, I was into 2 interviews to be the police commissioner of Philadelphia. I was also on the final interview to be the head of police philanthropy for a major philanthropy organization. And my mayor said, this is a tremendous fight. The socialists have their knives out. I can invest in your career, but you've already applied to other jobs. So I resigned. Does that make sense? Does that answer your question, Representative Alexander?
It does. I just have a quick follow-up.
You may.
Sure.
Thank you. So in New Hampshire RSA, I believe it is, if I said it right, hold on, I just want to pull the correct one. RSA 31:104, it describes a cause of action that a citizen can use against a police officer who, quote, does wanton or reckless misconduct. So in your personal capacity, would you qualify that situation with the license plate as a wanton or reckless misconduct of a police officer that would actually be a cause of action existing in the state?
No, not the license plate per se, but the gunfire. You could, if the person is unarmed, if the person is standing up, that there's no indication that there's an imminent threat, which is again a matter to litigate, right? I'm not going to go back and litigate on those particular facts, but shooting an unarmed person in their own driveway in their own home when there's no weapons in their hand, like that could seem like something that would be a cause of action.
Thank you.
Any other questions for Mr. Del Pozo? Yes, Representative Trotter.
Thank you, Mr. Chair. Mr. DePozo, quick question. You said you were from Vermont. Did they have qualified immunity there?
So no, right now, Vermont, there's no, when you say they have qualified immunity is we're considering it as a federal doctrine. So it applies federally. If you're asking if they had a state recourse, no, they don't have a state recourse.
Thank you.
Any other questions for Mr. Del Pozo? Seeing none, thank you for your testimony today.
Thank you.
John Krupski. Need to raise your hand, Mr. Krupski, so we can see you. Did you find it?
Mr. Chairman, can you hear me?
We can hear you. You asked for 3 minutes, Mr. Krupski.
Yes, and I'll try to adhere to that to the best I can.
I'll try to hold you to that.
Good morning, Mr. Chairman, and members of the committee. Thank you for allowing me to testify. I'm here on behalf of the New Hampshire Police Association, and we are against the amendment for a variety of reasons. We initially testified in support of SB 96, but if this amendment is adopted, we cannot and will not support SB 96 or the amendment. We're against the amendment for policy reasons, because we believe as it's currently written, it will impair contracts in violation of the federal and state constitution. 3, that the name of the bill of creating a cause of action already exists, that it treats public employees disparately, not only police officers. There are language problems with the bill, and it encourages the proliferation of litigation. I believe that the policy reasons have been articulated in previous testimony. Most among them is the inability of government to conduct itself in a reasonable manner and would deter, and there would be a loss of productivity in the operations of government. I think that the policy reasons are implicitly recognized in this amendment, because the amendment actually adopts and retains so-called official immunity for judiciary and legislative immunity. And that's at section 507H4, Roman numeral 3, and it would be also be located on page 2, lines 20 through 22. It seems to me that the bill or the amendment as it's constituted recognizes the importance of the policy considerations for the legislative and judicial functions, but excludes the individuals who are required to enforce those edicts from having any immunity. We think that's fundamentally unfair. Number two, we believe that it impairs contract as an illegal impairment of contract. I believe that the Justice Lynn spoke to that at length, but I do point you to section 507H6, which is at page 2, lines 35 through 38. In that, it specifically says that notwithstanding any provision of law, contract, or agreement to the contrary, an individual may be fired for a violation of any constitutional rights. Think of the unfairness of this, because in a collective bargaining agreement or other contract that is provided, a just cause clause often is contained therein, which requires an employer to meet a 7-point test. It is now eliminates that important provision. That impairment would be an impairment of the contractual relationships. It would impair the relationship, and it would be substantial, as is recognized by the courts in that regard. For the other reasons stated by Judge Lynn, which I'm trying to go through this quickly to fit within the 3 minutes, we would also adopt those arguments. The access to the courts already exists. I think that was set forth by Judge Lynn, but I also point the committee to 507B, which provides for access for bodily injuries for municipalities, 42 U.S.C. 1983 for federal constitutional violations, and 541B, which allows for recovery for bad actions of the state. In fact, that's recognized by the bill when it says at the top that it supersedes 507B, 541B, et cetera. And that's at page 1, lines 15 through 18. We also believe that it treats public employees disparately. For example, there is legislative immunity and immunity for judiciary actions contained within the bill or the amendment at 507H4. Think about it from this perspective. It's not just police officers, but imagine an assistant clerk who's in a town enforcing a voting rights bill that has been passed, operates in good faith in trying to enforce the law, would create liability for that municipality and possibly the termination of that employee because it is later found to be unconstitutional. That employee is following the directives of the legislative body, whether it be local or statewide, and is fired. And in this amendment, it actually says that the good faith reliance by the employee can no longer be used as a defense.
Thank you.
We believe that the language is also problematic.
Can you wrap up, Attorney Trustee?
We believe the language is problematic because it refers to state agents, and government agents without a definition of either one, which means that this law may be applied disparately on the different levels. And we also believe that this would have many negative implications. Thank you for listening to my testimony, and I'd be happy to answer any questions that are outstanding. I tried to be as quick as I could, sir.
And it was appreciated. Any questions for Attorney Krupski? Yeah, Representative Trottier.
Thank you, Mr. Chair. Mr. Karofsky, quick question for you. You testified that if all of a sudden the legislative branch passes a law and a police officer acts upon that law under good faith, and it goes to court, and the court finds that it is unconstitutional, can that officer still be charged or, be sued for acting in good faith?
Yes, and because of that, I point you directly to the amendment at page 2, lines 16 through 17, which says that the court shall not be impeded by if the state agent acted in good faith or that the state agent believed reasonably or otherwise that his actions were lawful at the time.
Thank you.
Any other questions for Attorney Krupski? Seeing none, thanks for your testimony today.
Thank you.
The next person is Jerry G. Ask for 4 minutes.
Good morning. Are you able to hear me?
We can hear you. We do keep a record. Do you mind sharing your last name as well with us?
I'm sorry that I registered as that. It was a mistake. Thank you. My name is Jerry Greenfield.
Thank you.
And good morning, distinguished members of the Judiciary Committee. As I said, I'm Jerry Greenfield. I'm the co-founder of Ben & Jerry's Ice Cream, and I'm also the co-chair of the Campaign to End Qualified Immunity, a national coalition of business leaders, professional athletes, lawyers, former law enforcement agents, advocacy groups, and concerned citizens dedicated to holding cops accountable. I'm here today to express my support for the amendment. Ben and I both know that in the business world, accountability is the key to achieving results. This is even more critical with all government employees, especially law enforcement officers, who we pay to protect and serve us and authorized to use lethal force for our safety. The vast majority of public servants and police officers take this mission seriously, serving their communities with dedication and kindness. But there are bad actors too, those who abuse their power and bring harm to others. The Supreme Court dismissed the need to hold these bad actors accountable when they established the doctrine of qualified immunity, effectively giving government employees the ability to violate our civil rights without repercussions. And we've seen how this unfair and unjust policy is used, especially by bad cops. Accountability is not a burden to bear. It's an opportunity to build a better government. It's an opportunity to retrain and up-level government employees. It's an opportunity to attract high qualified candidates who are committed to service, and it's an opportunity to create a culture of excellence that will yield dividends for generations to come. If you want to build public trust in policing and public institutions, honor and support good law enforcement agents and tireless public employees, and respect the civil rights of New Hampshire residents, you have to support this amendment to end the unjust doctrine of qualified immunity. Thank you.
Thank you for your testimony. Are there questions for Mr. Greenfield? Seeing none, again, thank you for your testimony today.
Thank you.
Cordell Johnston. Okay.
Thank you, Mr. Chairman. Cordell Johnston, representing the New Hampshire Municipal Association in opposition to this amendment. First of all, I want to thank Representative Birch. I think it was me he was referring to as the NHMA lobbyist who is, I think he said, a kind and thoughtful person. I think he is also a kind and thoughtful person. and I probably agree with him more often than I disagree with him. And I look forward to sharing our bourbon recipes again when this is over. I do need to correct something he said, though. He said that the municipal association similarly opposed the taxpayer standing bill 3 years ago, claiming that it would lead to an explosion of litigation. We did not oppose taxpayer standing. There were people who did, and they did make that claim, but we did not. We, in fact, worked on that. We didn't support it, but we didn't oppose it either. So I just wanted to clarify that. But this bill is different. This really is a problem. And let me be clear about this. We do not have any argument with the proposition that government actors, whether it's police or anyone else, ought to be accountable for obvious misconduct. And in almost all cases, at least in New Hampshire, they already are. Citing a few cases from other states doesn't change that. And I note that I think we've heard from 4 witnesses other than the sponsor in support of this bill, 3 of whom were from outside New Hampshire. I think I would encourage the committee to listen to New Hampshire voices on this bill. But if you want to pass a law that does provide more assurance of accountability for bad actors, we can get behind that, and we're even happy to work on it. And Representative Lynn suggested the same thing. But that's not what this bill does. This bill makes local governments liable for innocent mistakes by good actors, and for things that aren't even mistakes, just differing interpretations of the law. And I could give you dozens of examples of situations where this could come up, but I'll just give you one. I'm the moderator in my town. And by the way, someone said that this bill protects all elected officials. It does not. It protects legislative officials, but not all elected officials. So at our town meeting, somebody gets disruptive. So I have a police officer escort him out of the building and detain him until the end of the meeting, which the law gives me the authority to do. He sues me, and he sues the police officer for violating his First and Fourth Amendment rights, and the judge agrees. Now, under current law, these are the kinds of good faith decisions that the police officer and I would be protected from. Government actors have to make these decisions every day, and they're protected. But this bill would eliminate that protection. Yeah, I don't get sued personally, but the town is now subject to liability for damages and for attorney fees, where I and the police officer have just followed a reasonable interpretation of the law. As I said, I could come up with dozens of other examples, and I have in some of my correspondence. So if there are changes that need to be made to tighten up the accountability for actual misconduct, for intentional misconduct by whether it's police officers or others, as I said, we're happy to work on that. But to take a sledgehammer to the entire system to get rid of qualified immunity is not the answer. So I very strongly encourage you to reject this amendment. Thank you very much.
Are there any questions for Mr. Johnston? Seeing none, thank you for your testimony today.
Thank you.
Jay Schweiker.
Thank you. Can you hear me?
We can.
Great. Thank you very much. My name is Jay Schweikert, and I am a research fellow with the Cato Institute. And my focus for the last 3.5 years has been the doctrine of qualified immunity. And that doctrine is obviously at the center of these discussions today, but I think it would be helpful to provide a little bit more background and explanation on exactly how this doctrine works in practice and what eliminating it would and would not mean.
As long as you can do that in the 5 minutes you've asked for.
Absolutely, absolutely. So the key feature of qualified immunity that actually hasn't been discussed is the clearly established law standard. The way that qualified immunity works is if someone's constitutional rights have been violated, a plaintiff, to get relief for that violation, also has to show that that right was, quote, clearly established at the time of the violation. And in practice, what that means is that they have to find a prior judicial decision in their jurisdiction with functionally identical facts as their own case. What this means is that although we've been discussing concepts like reasonableness and good faith, qualified immunity actually has nothing to do with reasonableness or good faith. The only thing that matters with this doctrine is whether the law was clearly established, which again generally means whether there were sufficiently similar facts in prior judicial decisions. So just to give a couple examples of this, in the case Jessup versus City of Fresno, which Representative Birch touched on in his opening comments, the court granted immunity to officers who were alleged to have stolen over $200,000 in cash and rare coins while executing a search warrant. They received qualified immunity, not because they were acting in good faith. Of course they weren't acting in good faith. They received immunity simply because that court had not yet issued a decision addressing that exact question. Similarly, in a recent decision called Frazier versus Evans, police officers violated a man's First Amendment rights by illegally searching and threatening to arrest him for recording them in public, something that he had a First Amendment right to do. And these officers had been explicitly trained that citizens do have a First Amendment right to record the police in public. They knew they were violating this man's rights, but they received immunity because while 6 of the federal circuit courts had explicitly addressed this question, the one particular court where this occurred, the 10th Circuit, had not. So in other words, this doctrine turns entirely on the happenstance of the fact patterns of prior cases, not on whether a defendant was acting reasonably or in good faith. Another misconception of qualified immunity that I want to address is that it has nothing to do with deterring frivolous lawsuits. A frivolous lawsuit, by its very nature, is one that is not meritorious, either whether it's factually unsupported or legally unsupported. But qualified immunity only matters. It only does work in the instance where someone's rights have been violated, but where a court determines that those rights were not clearly established. So for qualified immunity to make the difference in a case, it must necessarily mean that the case was not frivolous, that there was a meritorious claim. When cases are genuinely frivolous, there are other tools of civil procedure that are perfectly capable of dismissing those suits. So whether or not frivolous lawsuits or frivolous civil rights lawsuits are a problem, it's just not something that qualified immunity is geared to address. And finally, I want to briefly touch on this question of state law remedies. And just to explain why state law remedies are not an adequate alternative to a robust civil rights law for addressing constitutional violations. And there are 2 main reasons. One is simply that most state law remedies do not include attorney's fees. And now, Judge Lynn, I believe, recognized that he might support attorney's fees, but more generally, without attorney's fees, most civil rights plaintiffs are simply not going to be able to bring a case at all. But additionally, although there is some overlap between state law remedies and constitutional violations, it's by no means complete. There are all kinds of constitutional violations of free speech and freedom of religion, racial discrimination, trial rights, and many others that simply cannot be redressed through traditional tort law remedies. And that's why a robust civil rights law is essential. And with that, I'm happy to answer any questions.
Are there any questions for Mr. Schweikert? Seeing none, thank you for your testimony today. It's Greg Martakos. If you are there, raise your hand so we can see you. Don't see you. Mark Bowden. Well, Mr. Bowden.
Good morning, Mr. Chairperson. Thank you for taking my testimony, and thank you to the House Judiciary Committee for allowing me to speak today.
No problem. You asked for 2 minutes. So.
I'm going to be very quick. My name is Mark Bodwin. I'm a retired sergeant from the New Hampshire State Police. I'm currently the executive director of the New Hampshire Troopers Association. We are in support of SB 96 for the Lee Act, but we are against the amendment that is brought forward by Representative Birch. We believe that this is a national narrative that is being pushed on the state of New Hampshire. I think you've heard many people today testifying. They're all from, a good chunk of them are from out of state that are in support of this. This is a solution looking for a problem. None of them have mentioned any issues that have been going on in New Hampshire as to why this desperate change needs to be made. We are also experiencing a recruitment and retention issue here in New Hampshire with our law enforcement. Although we try very hard to recruit the very best, we're finding that to be more and more difficult as time goes on. Currently, as you heard from a lot of the other people that testified in opposition to this amendment, bad actors are held accountable. There is a way to hold them accountable currently through current law. So public employee sectors don't get 100% immunity. All right, if they act in a reckless or wanton manner, they can be held accountable for civil suits. This is and speaking as a citizen and as a resident of New Hampshire, I'm also concerned about some of the things that the municipalities brought forward. I pay a hefty property tax already. I don't need my taxes going up as a result of this, whether it's through insurance costs or lawsuits. And as many of you know, a lot of these lawsuits are settled with nuisance money, which will add up after a while. And it's the public that will be paying for that. So I'm not going to reiterate a lot of what was already testified to. We are in opposition of this bill. We don't feel that this is good for New Hampshire. We don't feel it's right for New Hampshire. We don't see that New Hampshire is currently experiencing a problem with this, and that there would be a lot of unintended consequences as a result. And with that, I thank you for listening to my testimony. And if anyone has any questions, I'd be happy to answer them.
Thank you for your testimony. Are there any questions for Trooper Bowden? Seeing none, again, thank you for your testimony. Ken Norton, who asked for 1 minute.
Good morning, Chairman Gordon and committee members. My name is Ken Norton. I'm the Executive Director of NAMI New Hampshire, the National Alliance on Mental Illness, and I was one of the 14 members in the Lee Act Commission. And I would echo the testimony by my colleague, Ani Malachi, in opposing this amendment. I take no position on the content of the amendment itself, but I would just contrast the hearing last week on Senate Bill 96 itself, where there was almost complete unanimity in support of the bill itself, with this morning's hearing with the controversy regarding the amendment. And I think it would be shameful if we jeopardized the contents of Senate Bill 96 by trying to attach this amendment to it, which should have its own hearing. So I would ask you to vote this amendment to inexpedient to legislate, and I'm happy to answer any questions.
Thank you, Representative Alexander.
Thank you, Mr. Chair. Thank you, Mr. Norton, for taking my question. Would you classify this amendment as a poison pill on the work that the Lee Act Commission did for police accountability?
Thank you for your question. No, I mean, I think it's well intended. I understand why this is important for us to have a conversation about it in New Hampshire. I actually liked Representative Lynn's suggestion that perhaps this should be a study committee. I just don't believe that it should be attached to this bill.
Thank you.
Any other questions for Mr. Norton? Seeing none, thank you for your testimony today.
Thank you.
Michael Sitar. Sitar, S-I-T-A-R.
Mute. Good morning.
Morning. We can hear you fine.
Good morning, Chairman Gordon and members of the House Judiciary Committee. My name is Michael Setar, and I offer this testimony as the president of the New Hampshire Association of Fire Chiefs. I also serve as the fire chief for the towns of Tilton and Northfield. As a quick background, the New Hampshire Association of Fire Chiefs provides leadership, education, and advocacy for the New Hampshire Fire Service. The New Hampshire Fire Chiefs Association are opposed to the proposed amendment. As you know, many communities in New Hampshire rely on call firefighters as first responders. A recent article from the Concord Monitor highlighted the challenges communities are having to find individuals willing to serve as call firefighters. Full-time departments are experiencing the same challenges. If SB 96 were to become law with the proposed amendment, those who are willing to serve their local communities as call firefighters, or those who consider a career in the fire service, may decide against doing so to avoid the associated new potential for being the subject of a high-profile lawsuit, which could result in their termination. New Hampshire full-time and call fire departments must compete with the private sector for employers, as well as departments in other states. Creating an environment which makes New Hampshire less attractive will only exacerbate these problems. The New Hampshire Association of Fire Chiefs opposes the proposed amendment and asks you to do so as well. We have submitted our comments in writing for your reference, and I thank you for your time this morning. I'd be happy to answer any questions.
Thank you, Chief. Are there questions for Chief Setar? Seeing none, again, thank you for your testimony today.
Welcome.
Attorney Richard Head.
Good morning, Mr. Chairman. Can you hear me?
We can hear you fine.
Excellent. Thank you. For the record, my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do not take any position on the policy of this amendment. I started with one request, actually, based on the testimony. I have two requests. And I know in a U.S. Supreme Court opinion that expanded the 1983 coverage in federal lawsuits, a dissent from Justice Powell that said no one can foresee the number of new filings in our already overburdened courts, but nobody can doubt the consequences that it will be substantial. My first request, and this relates to the fact that House Bill 111 did not have a fiscal note, is that if this bill is ultimately supported by this committee, that it be referred to the LBA for a fiscal worksheet. I think it would be useful for the House to have information with regard to the potential fiscal impacts. And we certainly do not take a position on the policy, but we do believe that there will be an increase in the number of lawsuits filed, and that will have an impact on the resources of the court. And we would potentially be looking for resources that would cover that either now or down the road. So I do think it would be useful and instructive for the legislative branch. My second request relates to the testimony, and I understand that the focus of this has been on qualified immunity, and I just point to page 1, lines 30 to 32 of the bill, and suggest, and again, have no policy opinion or view on how this might turn out, but suggest perhaps a referral to the Attorney General as to the scope of what this means. Because it does say an individual may seek legal, equitable, or other relief under this chapter in state court for an injury caused by an agent of the state of New Hampshire or a political subdivision in violation of a right under the laws or Constitution of the state of New Hampshire or the United States. And I do think it might be useful, especially from my perspective, in putting together a fiscal note as to whether or not that phrasing expands the scope of this bill beyond qualified immunity. And again, whether or not it does is not something that we are opining on, but it may ultimately have this one.
Okay.
And I thank you for your time. I'd be happy to answer any questions.
Thank you. Are there any questions for Attorney Head? Seeing none, thank you for your testimony today.
Thank you.
Kirk Beatty.
Good morning. My name is Kirk Beatty. I'm the fire chief for the city of Laconia, and I'm also the first vice president for the New Hampshire Association of Fire Chiefs. And I'm here speaking in opposition to the amendment for Senate Bill 96. As Chief Sitar stated, the New Hampshire Association of Fire Chiefs did send out a letter in our opposition. I just want to make a couple quick points. I know it's been a long morning. I'm going to keep it very, very short for you.
Good.
We're not looking to protect. I think these are two key points. Number one is we're not looking to protect, nor do we support reckless and wanton actions. What we do want to ensure is that firefighters, EMTs, and agencies we oversee, both an emergency and a non-emergency response, are not subject to unnecessary litigation. We believe that the current New Hampshire laws strikes that right balance. I told you I'd keep it very short. I think those are key points. Thank you for your time this morning.
Thank you very much, Chief. Are there any questions for Chief Beatty? Seeing none, thank you again.
Thank you.
The next person is Thomas Mullins.
Good morning, Mr. Chairman and members of the committee. I understand you can hear me at this point. Is that correct?
We can hear you fine.
Yes, thank you. My name's Thomas Mullins. I'm the city attorney for the city of Keene. Speaking on behalf of our city council who asked me to attend the meeting. I did ask for 3 minutes, and I promise they will be 3 real people minutes and not lawyer minutes, as a bailiff once said to me. So I'll try to keep it short. In short, yeah, I'm in favor of the testimony that you've heard in opposition to the amendment. In particular, Representative Lynn's comments. You know, respected jurist in the state, and his comments were right on. A couple of real world applications for you. First, we think the amendment sweeps way too broadly. You've heard those comments that with all due respect to the police officers who have a terrible and difficult job, it's not just directed at the police officers, it applies to all of our employees. And in a couple of real world consequences, for example, we now have a lot of RSA 91A requests. 91A is a statute that arises under our state constitution. So it is a sort of constitutional right that's provided. Our Supreme Court recently decided that personnel records and files are no longer sort of per se exempt. So we have to do a privacy analysis to make a determination as to whether or not those files should be released. If we are wrong and guess wrong, and the judge decides that we were wrong, then potentially there was a violation of law that arises from a constitutional right committed by a city agent, which would make that individual, not the individual liable, but the municipality liable. So that we think that just sweeps too broadly. The second point I'd like to make is, you know, we've talked a lot about the 1983 action and qualified immunity. This is a state law that we're talking about, but it doesn't prevent a plaintiff from going into federal court seeking 1983 damages against the individual agent, even though the state law does not provide for that. So we would urge you at this point to not to ITL this amendment. I'm also finally not going to say to you that we don't think that there are some issues with qualified immunity. You've heard some of those already. Those probably need to be addressed. I work with very professional people who are very well trained, but we all make mistakes. And basically what this amendment does is punish state city employees for making good faith mistakes. So on that note, Mr. Chairman and members of the committee, I'm happy to answer any questions, but otherwise, please note our opposition to the amendment and request that it be ITL'd. Thank you.
Thank you. Are there any questions for Mr. Mullen, Attorney Mullen, excuse me? Seeing none, thank you again for your testimony. The last person who pre-registered to testify is Matthew Rodhead.
Good morning, Chairman. Can you hear me?
You can.
Thank you, Chairman, and thank you, members of the committee, for working on this important issue and on this important underlying bill, SB 96. My name is Matthew Broadhead. I'm a Senior Assistant Attorney General here at the Department of Justice. I am the Bureau Chief of the Transportation Bureau, but I'm actually appearing today on behalf of the Attorney General, John Formella, and all state agencies. And we do oppose the amendment. We do support the underlying bill, SB 96. The original language was based on consensus. This inserts a issue that's non-germane to what was trying to be accomplished by the original language of SB 96. I can't overstate that the original bill was built on consensus, and that included support from the law enforcement community as well as community stakeholders. And this kind of risks torpedoing what progress we can make on police reform and needed transparency. So we oppose on that ground. We also, without taking a position on the overarching policy, we do oppose the language of the amendment because it, I think a previous person testified that it takes a sledgehammer. We think, it takes a hatchet to our statutory scheme where a scalpel would be more appropriate. And if I don't want to echo, or repeat what's already been discussed, but we also share the same concerns that former Justice Lynn, representative right now, had testified to in terms of qualified immunity as a creature of federal law. There are other immunities under state law that are that this bill would appear to override. And I'm just going to list them off because they're found in RSA 541B and RSA 99D. And if the members of the committee are not familiar with these immunities that would now be waived, then I recommend this issue for further study so that you can familiarize yourself with these issues to determine whether or not, as a matter of policy, you would want to waive them. They include discretionary function immunity, recreational immunity, prosecutorial immunity, due care immunity. That's a statute that says that a state employee can't be liable if they're exercising due care and exercising their statutorily obligated functions, which you all set. Intentional tort immunity, 11th Amendment immunity. This would waive 11th Amendment immunity that the state enjoys in federal court, which basically serve as a buttress that any claims against the state are not decided by a federal judge in federal court. They're decided by state judges and state courts closer to the community that we serve. That's an important policy decision to make. So if you're not familiar with the issues, I commend that for further study. Further, now RSA 99D gives the state the option to whether or not to represent a state employee who's acted recklessly or wanton with regard to their duties. And that does create personal accountability for state employees if they are wanton or reckless. And therefore, it could have a perverse effect. Waiving that would have a perverse effect in that those employees are free to do what they want and knowing that they'll be fully defended and indemnified. So that, I think, is concerning. There's also a statutory cap on damages with respect to the state so that the budget doesn't get impacted by a flood of claims. There's a $475,000 cap on damages so that it doesn't affect the bottom line or the functioning of government. This would waive that. There's other drafting issues, but I'll just leave it at that. I'm happy to take questions. I do, if I may, Mr. Chair, just want to correct one misperception about what qualified immunity is in federal court. There was somebody from the Cato Institute who I think misquoted the case law in the First Circuit, which governs New Hampshire. You don't need to prove that there's a spitting image case. There's a case, it's called Belcito v. Decker, a case that I argued at the First Circuit. And you don't, to prevail on qualified immunity, you don't need to show that there's a case, prior case on point. That's exactly factually the same. They don't generalize it at that level of specificity. Okay. You don't need to show that it's a spitting image of a prior case. It protects all but the plainly incompetent or those who act intentionally. So it protects officers who make bad guesses in gray areas, not intentional or incompetent conduct. So that's all. I'll leave it at that, and I'm happy to take any questions. Thank you.
Thank you, Attorney Broadhead. Any questions for Attorney Broadhead? Seeing none, again, thank you for your testimony. Again, that concludes the people who pre-registered to testify today. There are some hands up. I see there are 4 hands up. One, no name, no last name, but named Jeb.
Good morning, Mr. Chairman. It's Brett.
Yes.
It's nice to have a unique name. I apologize for I didn't think I'd have a chance to testify this morning, giving hearings going on in the Senate. As I said last week in the hearing on the underlying bill, I think that there would be a significant problem if this amendment were attached to Senate Bill 96 and come over to the Senate, not having had the chance to have a hearing. That would be a problem. I agree with the testimony of many witnesses. I've only heard a few of them, but I in particular agree with the points articulated by Cordell Johnson of the Municipal Association, that what the amendment tries to do is solve a problem that does not exist in New Hampshire. There's no identified New Hampshire problem. I think you've heard significant testimony about the stress that it would place through unnecessary litigation on all New Hampshire towns, but in particular on the people that protect us, our police and our firefighters. So I hope you reject the amendment and pass the underlying bill. Thank you, Mr. Chairman.
Thank you. Are there any questions for Senator Bradley? Seeing none, thank you for your testimony today.
Thank you.
Robert Quinn.
Good afternoon, sir. Can you hear me?
We can hear you fine.
Oh, great. I'll just take 60 seconds, and I apologize for not pre-registering. Thank you for having me on. Robert Quinn, for the record. I'm the Commissioner of the Department of Safety. We have 7 divisions, which include not only the state police, embedded in the state police are the campus police, the Marine Patrol officers. We have the Fire Marshal's Office, the Fire Academy, Homeland Security, and Emergency Management. Our mission is to make New Hampshire the safest state in the nation with the highest quality of life for all. I just want to say a lot's been said today, and what I would like to just kind of emphasize is this. When New Hampshire responded to events that were happening around the country, we looked at making New Hampshire law enforcement kind of the leaders and in transparency and training and accountability. I will just echo that we met for 26 times. And when you use the word consensus, we listened to the public. We had a diverse group on that LEAC commission. We worked very hard and we reached consensus on 48 items that I think really move us forward in training, community engagement, accountability, hiring issues, recruitment. I mean, we looked at this thing and we worked very hard. I oppose this because although I support the SB 96 and all that's in it, I want to see us continue to move forward. When LEAC ended, to this day, we continue to work very hard on implementing those changes, improving the training, improving how we hire, and just making positive movement on the LEAC recommendations. So not only as Commissioner of Safety, but as a member of the LEAC community, I oppose this. I think there are other opportunities to study this issue, but I do not want to put us backwards. And I think that's what this would do. So happy to answer any question. Thank you for allowing me to raise my hand and jump in, Judge.
Thank you, Commissioner. Yes, Representative Trotter.
Thank you, Mr. Chair. Commissioner Quinn, just one quick question. When New Hampshire started seeing a problem across the country, you're saying New Hampshire took a proactive approach to deal with these type of issues in New Hampshire before they started to happen?
I believe we did. And I think that if I would encourage everyone to look at the document, what LEACT looked at, we addressed, and I think we're forward leaning. And quite honestly, I think we have a great culture that recognizes mistakes, do occur, but we need to provide the best training, the best resources. And I will say this, there are challenges today that, I did not face when I got hired in 1985 as a state trooper. And we have to continually improve and enhance. And that is what the LEACT commission did. And I would say yes. And I would put that, that product, up against anything that's been done. And I encourage everybody to read it. And once you read that, you will understand there are great things that have been happening, are happening, and we are moving in the right direction.
One quick question.
Yes,
follow up. Commissioner, if this amendment passes and becomes law, do you see this affecting the safety in New Hampshire?
Absolutely. And I'll keep it as simple as this. It is getting very hard to recruit and retain the best. And we have not lowered our standards. I think we have to continue to support our first responders, to support them, address mistakes that have been made, be transparent. But without that support, quite honestly, you're not going to see the interest. And that's discussed nationally. I mean, that's happening all over the country.
Thank you, Commissioner.
Any other questions for Commissioner Quinn? Seeing none, thank you for testifying today.
Thank you.
Joseph Hobecki.
Mr. Chair, can you hear me, sir?
We hear you fine.
Okay, great. My apologies. I believe I pre-registered, but for some reason I wasn't included on your list. And with your permission, sir, I'd like to have about 5 minutes. I timed myself last night, so I'll keep it to that. So.
Hey, if you, I'm going to hold you to it for sure.
Okay, sir. So again, for the record, Mr. Chair and members of the committee, my name is Joe Hobecki. I'm the Chief of Police in Hollis, New Hampshire. This past February, I completed my 20th year of service to the state of New Hampshire. And I'm sincere when I say that serving the citizens of this great state has been the honor of my lifetime. I submit my testimony today in strong opposition to the amendment to Senate Bill 96, a bill which I originally worked on as part of the LEACT Legislative Work Group, which, as introduced by Representative Birch, will eliminate qualified immunity and official immunity in the state of New Hampshire. Although it is clear that the focus of this bill is directed at law enforcement, the abolition of qualified and official immunity will extend to many other dedicated men and women serving within the public service professions in the state. On Friday of last week, as I have for many years, I had the honor of spending the morning at the New Hampshire Law Enforcement Memorial, located just outside the building in which many of you sit. As I listened to the solemn remembrances of the 50 names etched into the granite columns, I thought about the incredible sacrifices that these individuals and their families have made to the state. They represent the finest that the law enforcement and corrections professions have to offer, as they made the ultimate sacrifice to preserve the safety that each of us enjoys. In reflecting on these sacrifices, I could not help but consider the events that have occurred over the past year, where we have seen this ongoing dialogue and conversation about the proper role of police in society. There is no doubt that the profession I love is not without fault. I want to make that very clear, but I'm quite certain that we can all agree this is true of every profession on this planet. Wesson Dunn, who's a retired FBI agent, I think eloquently said and describe policing by saying this: our society expects a lot from officers. We expect them to confront potentially dangerous individuals so many others do not have to do so. We expect them to deal with horrific scenes that would give most people nightmares. We expect them to react with unwavering compassion and understanding when dealing with people experience the worst moments of their life, regardless of the officer's own life stresses. We expect them to react calmly and professionally when confronted with verbal and sometimes physical abuse. We literally expect them to run towards the sound of gunfire while others are running away. Police officers live up to these expectations every day. And this is most certainly affirmed as you look at the names of the courageous individuals etched into the wall of the Law Enforcement Memorial. Today, you have heard from individuals who are passionate in either their support for or their opposition to the amendment. Those who support the amendment will argue that qualified and official immunity essentially says that police officers and other public servants are above the law. Although I oppose this amendment, what is most important for you to understand is the impact of the removal of qualified and official immunity. There is no doubt that policing and law enforcement in the United States must continue to improve to better reflect the expectations of our changing society. In considering police reform, we must balance the impact and potentially negative consequences of such effort. It is not true to say that qualified and official immunity prevents accountability for police misconduct. And to the contrary, it protects both society and law enforcement in a carefully balanced manner that has been refined by the courts over many years. It permits officers to perform their duties without fear of constantly defending themselves against tenuous claims. And it allows the public to recover damages when a reasonable officer would know that their conduct violates a person's constitutional or legal rights. Make no mistakes, law enforcement is a difficult profession with many challenges and risks, as well as significant intangible rewards. Law officers often make split-second life or death decision where any hesitation can result in serious injury or death. We rightfully expect a lot of law enforcement officers because we entrust them with significant power and authority. However, we should not expect them to be injured or killed while doing their job, nor should we expect them to put their livelihoods and the financial welfare of their families on the line every time they are forced to make a split-second life or death decision. In closing, I remind you that the laws are the fabric of a civil society. We entrust law enforcement officers with the power to uphold and enforce those laws. Law enforcement officers keep the fabric of our society from being torn apart by those who have no respect for others. If you pass this amendment, eliminating qualified and official immunity, you will do nothing more than make an already difficult and challenging profession even more dangerous and complicated. There is no, and this is my closing statement, there is no better reminder of these dangers than those granite slabs prominently erected outside the Legislative Office Building. For these reasons, I ask each of you to vote no on this amendment. Thank you for your time. Be happy to answer any questions you have.
Chief, are there any questions for the chief? Seeing none, thank you for your testimony. And the last person to testify is Jim Kennedy.
Good morning, Honorable Chairman, members of the Judiciary Committee. My name is Jim Kennedy. I'm the City Attorney for the City of Concord and former Assistant Attorney General here in the state of New Hampshire. I echo the comments offered earlier by Cordell Johnston, our former Chief Justice of our New Hampshire Supreme Court, now Representative Judge Lynn, Thomas Mullins, and our Senior Assistant Attorney General, Matt Broadhead. Let me just say, without repeating everything that they've said, which I agree with in opposition to this bill, that House Bill 111 represents a significant threat to New Hampshire citizens and municipal taxpayers. The benefactors of this proposed legislation are those people claiming a right to sue for good faith conduct by our state and municipal employees. Their benefit should not be at the expense of New Hampshire citizens, and I urge you to oppose this amendment. If you have any questions, I'd be happy to answer them.
Thank you for your testimony. Any questions for Attorney Kennedy? Seeing none, thank you for your testimony today. And that closes the hearing on Amendment 2021-12448. And I think what we will do is take a recess. What I'd like to do, I think rather than take a lunch, I think we probably can take a recess, come back and finish up relatively quickly with our executive session, if that's okay with everybody. And so it being about 1:15 right now, why don't we reconvene at 11:30? And so we will be in recess until 11:30. And we'll have if I could just have the Republicans stay for a moment and join us perhaps in the room adjoining here. We'll have a brief caucus. Thank you.
You guys thought I was late last week.
Why don't you go to another room?
I'm just going to go ahead and mute the room for Judiciary.
Thank you.
Jen, how do you get to the caucus in the other room?
Representative Kelly, you may want to call into one of the members.
Could you tell me real fast how to do that?
Do you have just a cell phone number for someone? Representative Alexander, Representative Gordon, McLean.
Oh, okay. I'm trying to think just their cell phone numbers.
That's what I would recommend, since they're kind of on the fly. We don't facilitate party caucuses.
Darn, I'd like to hear what's being said, but yeah, I don't have a whole lot of people's numbers.
Okay.
Okay. Mike's calling me.
Okay, perfect.
Hey.
Depends on which clock you go by too. Split the difference of it just on time. 5 minutes.
Might I inquire before we get started whether there are any other amendments that the committee might be considering on SB 96, or is it just this one?
No, I believe that well, the committee was presented with 4 potential amendments. There was the amendment that you proposed, the one that we just heard. There was an amendment that was proposed by Representative Di Lorenzo, and there were 2 amendments that were proposed by Representative Alexander, or not proposed, but were distributed.
Right, that's what I thought. So I assume one way or the other, those will be disposed of.
I'm presuming. In any event, I'll call the House Judiciary Committee back to order. We're here at this point in time for executive session. This is an executive session on Senate Bill 96. This is a bill relative to implicit bias training for judges, establishing a body worn, an in-car camera fund, and making an appropriation therefore, amending juvenile delinquency proceedings and transfers to Superior Court, and establishing committees to study the role and scope of authority to school resource officers and the collection of race and ethnicity data on state identification cards. And we are here for executive session. We had the hearing on the bill itself last week, and we had a hearing today on a non-germane amendments this morning. And I think since we had the hearing this morning, I guess Representative Birch, I'd call upon you first today if you want to offer that amendment.
Thank you. I do want to offer the amendment and make a few comments about this morning, which I'll keep.
So are you moving the adoption of the amendment?
I'm going to do that right now. Mr. Chair and committee, I move adoption of amendment 2021-1244H. I would like to just speak very briefly.
And is there a second to that? No second? Yes, seconded by Representative Kenny. Go ahead, Representative Birch.
Thank you. You all know how I feel with the bill so far, and we've had a lot of debate. I want to just clarify 1 or 2 things that were brought up this morning. One is the difference between good faith and reasonability. Anybody can claim good faith, which is why the courts tend not to utilize that in bills or laws such as this. I can say I put my foot on somebody's neck until they were dead, but I thought I was doing the right thing. Let me off the hook. I was acting in good faith. That doesn't fly. The obligation to act in a reasonable manner is the standard that the U.S. Supreme Court has handed down, that's reflected in the bill. So I think it's important to separate good faith, which is not a workable concept, with reasonability, which is. Secondly, we heard a lot about 2 or 3 major topic areas. One had to do with cost. And I think, to put it baldly, no pun intended, but to put it boldly, we're talking about the costs to recompense individuals who have been harmed by government action. And there's something fundamentally flawed by saying, oh, we shouldn't have to pay those costs. We shouldn't have to incur costs. If people were harmed by the government, that's their tough luck. I don't think we should operate that way. I don't think we have, and I don't think we should. So costs are directly related to bad acting. And that's the next point I wanted to quickly make. We're talking here only about bad actors and their liability, period. It's not more complicated than that. We're told two conflicting arguments. We're told on one hand, there will be huge consequences if we eliminate qualified immunity in New Hampshire. You know, people are going to get sued left and right. Nobody is going to join departments. Towns' taxes are going to go up, every horrible imaginable. Then we're also told there's no problem in New Hampshire. Both of those cannot exist in the same universe. Because if there are really no problems in New Hampshire, then costs are not going to go up. If there are all of a sudden in a particular police department a lot of suits, maybe somebody needs to pay attention to why there are in that particular police department. But you can't say that there's no problem, and if we allow victims to sue, then the sky is going to fall in. And the last comment I wanted to make is the issue of transparency. We heard a whole lot of patting ourselves in New Hampshire over on our shoulders about how transparent we are and how transparent we're working. No, we're not. And that's why we have legislation in a number of areas, because we don't have transparency. Number one, we keep bad police officers on the force in New Hampshire. And don't take my word for it, we have a Lori list. Now, we can't see yet, and maybe in our lifetime we will, but we don't know all the names on the Lori list, but we know for a fact that we keep bad cops on the job. Secondly, when bad cops who are on the job act badly, we want to give them immunity. And that's what this bill is about. And the third leg of this tripod is if there is a settlement, then in New Hampshire, we bar the harmed citizen from talking about it and the bad conduct through non-disclosure, non-disparagement agreements. So by the time you put all three of those together, I don't think we should be going around patting ourselves on the back about how transparent we are in New Hampshire, because we're not. So this bill is an attempt to simply say, and it's not as complicated as most of these witnesses would put it, this simply says that the victims of government misconduct who have suffered a violation of their constitutional rights shall have a right to go to court and get redress, exactly what our Constitution has said since the 1700s.
Thank you. Any other discussion on the amendment proposed? Yes, Representative Alexander.
Thank you, Mr. Chairman. I have much respect for my friend from Westmoreland. He presents this amendment as a change or some changes from HB 111, but the House tabled that earlier this year. And to be clear, I really don't think there is much change. Amendment 1244 stems from a national narrative that doesn't fit with New Hampshire. and that is highlighted by the amount of out-of-state support it has. Most witnesses testifying in support are out-of-state special interest groups who failed to supply one single New Hampshire example of existing RSAs not being adequate enough. And yikes, we have almost 1,200 people that signed in opposition to this amendment. In fact, one witness in favor of this amendment was forced to resign after a series of social media posts that were initially denied. And I would remind the committee that that denial of wrongdoing is a reason placed on our lawyer list in New Hampshire. The sponsor of this amendment argues that the addition of the use of force language at the end of the amendment would help address some of the concerns raised during the session last month. I would argue it doesn't do enough. There are already causes of actions for when officials act in, quote, wanton or reckless manner. The New Hampshire Municipal Association has outlined this in their letter to this committee dated on March 1st, in which they describe the existing avenue in place, which addresses personal and individual liability of government employees. Employees would only be shielded from lawsuit liability if they believed their conduct was lawful and within the scope of the officers' or employees' official duties. Quote, wanton or reckless misconduct would not qualify. So the description by one witness as a shooting of an unarmed citizen in a driveway by a police officer, in my mind, and most minds, would qualify as, quote, wanton or reckless misconduct. I tabled HB 111 earlier this session in order to give the sponsor time to fix some major concerns the majority of the New Hampshire House had before delivering another copy of this bill. There's been additional language changes offered by constitutional law experts and other state reps, hoping to fix the concerns by many in the House last month. Amendment 1244 does not address the major concerns of HB 111, and this issue should never have been introduced again this year. The New Hampshire House has already spoken. SB 96 is an attempt to bring all groups together to come up with common sense solutions to enhance law enforcement accountability. There are many things I like in SB 96. However, if 1244 is added to SB 96, I cannot support the bill. I want to warn the committee that adding Amendment 1244 to SB 96 would simply disrupt months of conversation and compromise made by the LEAC committee. So in that way, I urge my colleagues to support the bipartisan nature of SB 96 and please vote no on 1244. Thank you.
Other discussion on the amendment? Representative Smith.
Thank you, Mr. Chair. Mr. Chair, I was and remain a very proud co-sponsor of House Bill 111. I believe that the issue that was addressed in House Bill 111 is relevant and important and should not be ignored. I was not shocked this morning, but was in fact disappointed by the ad hominem arguments that were presented, including arguments that had absolutely nothing at all to do with the proposal of Amendment 1244. The sky is not falling and would not fall. The scare tactics were, I thought, irresponsible on the part of public employees and those who were representing certain interest groups. There is nothing that we can do about frivolous lawsuits. Those of us on Judiciary know that. Frivolous lawsuits are going to be filed no matter what. The fact that they're frivolous means that they do not continue through the judicial process. And this legislation or this amendment does not increase that. The lack of respect that was shown this morning by those who testified against this amendment, making comments that would indicate that responsible public employees would no longer be responsible, but would turn their backs or sit, on their hands. I found that insulting to all public employees. I sent to this committee a week or so ago something that came from my town, from the town of Durham, in which you all got to read about what a careful, well-run, responsible police department that has achieved CALEA recognition does. And I insist that the town of Durham would have nothing to worry about because it's careful about who it hires, it provides supervision, it provides training, it provides accountability. But nonetheless, my town manager, who is quite a responsible individual, swallowed whole hog the information that he was given by the municipal association. And I guess that's understandable. The town spends a lot of money to the municipal association, so they're not going to walk away. All of this would cause me, under all circumstances, to support House Bill 111, as I did and still do, and to support Amendment 1244. However, I find myself troubled by the fact that, yes, this is the right pew, but I believe it's the wrong church. I think that the language in the amendment is something that I support, and I will work hard to pursue. But I think that the work that has gone on in LEACT has to be respected. A very strong argument could be made that there is so much support for LEACT that if this amendment were added, it would not in any way compromise or question or put into jeopardy the passage of the underlying bill. However, all of us have seen in this session any number of bills where irrational, illogical, ad hominem arguments ended up compromising the success of bills that should have passed. Therefore, I cannot tell you how great my reluctance is. I cannot tell you how great my sadness is, but legislating responsibly is a complicated issue. And in no way do I question my support, and I hope no one questions my support of the elimination of qualified immunity, but I am very reluctantly going to vote against the amendment, and I will be voting for the underlying bill with the hope that we will add back to that underlying bill a section that for some unexplainable reason the Senate removed, because I want to be absolutely consistent in supporting the work of LEACT, and that would include putting back in the one section that the Senate removed. Thank you for indulging me with this overlong statement, Mr. Chair.
Any other comments to be made? Yes, Representative Sylvia.
Thank you, Mr. Chairman. And I agree with my former chairwoman right up until her conclusion. She made numerous fantastic points. I think there's a lot of fear surrounding this issue, and I don't let fear control my life. I use it as a way to inform myself, but when it comes down to the end, I have to weigh the rational arguments. I believe that law enforcement in this state is doing a fine job, and that there will not be a swarm of lawsuits against law enforcement. Further, it's not just about law enforcement. Let's not forget that. This is about all government employees. And then, so I support the qualified immunity section of this. And then, while I was not on the LEACT commission. I appreciate all the great work that they did. I think this is actually, instead of a poison pill, an enhancement for the Lee Act. In that it's a statement that says, yes, we trust our police officers. We know we're not going to get sued. And it's an enhancement to Lee Act and in all of the good things that they're trying to do. So I think actually SB 96 without this amendment would be lesser and it would be more difficult to vote for because it's not complete without this. So I'm supporting this amendment, and if this amendment passes, then I will be supporting SB 96 as amended.
Thank you. Representative Simpson.
Thank you, Mr. Chair. You all know that I supported HB 111 and reforms to qualified immunity and any incentive to hire and train employees in a professional manner and to hold them to a high standard. But with all respect to my colleagues sponsoring this amendment, I'm disinclined to support it today. SB 96, as it came from our partner legislative body, consists of the reforms that the Lee Act Commission came to agreement on. I don't want to jeopardize the package of legislation containing these necessary reforms by adding an amendment regarding qualified immunity when there's clearly not a consensus from the stakeholders. Perhaps in the future, stakeholders will come together and come to some agreement about reforms to qualified immunity. But at this point, it's vital that we pass the reforms suggested by the Lee Act Commission already in SB 96. So I'll not be voting for the amendment today.
Thank you for your offer. And is there anybody else who wishes to speak to the amendment? Seeing none, we have a motion on the floor. That's a motion to adopt Amendment 2021-1244H. And Mr. Clerk, you could call the roll.
On the adoption of Amendment 1244H, Representative McLean.
No.
Representative Sylvia.
Yes.
The clerk votes yes. Representative Alexander.
No.
Representative Melvin.
No.
Representative Murner.
No.
Representative Green.
No.
Representative Kelly.
No.
Representative Rizzulo.
No.
Representative Trotter.
No.
Representative Smith.
No.
Representative Burke.
Yes.
Representative Horgan.
No.
Representative Di Lorenzo.
No.
Representative Rogers.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Marshall.
Yes.
Representative Page.
No.
Representative Simpson.
No.
Mr. Chairman.
No.
I have the vote is 7 in the affirmative, 14 in the negative.
Being 7-4, 14 against, the amendment is defeated. I guess Representative Di Lorenzo, did you want to bring forward your amendment?
Thank you, Mr. Chair. I'd like to speak to Amendment 1510. Thank you, Mr. Chair and honorable members of this committee. Amendment 1510 makes.
Yeah, can I just, you're making that a motion that we adopt that, Representative Di Lorenzo?
Yes.
And
I
is
would
it
second it.
seconded by Representative Smith? And go ahead, Representative Di Lorenzo.
Thank you, Mr. Chairman. Thank you, Mr. Chairman and honorable members of this committee. Amendment 1510 makes 3 changes to SB 96. One, this amendment reinstates the demographic data collection provision of SB 96 that was removed by the Senate, and it strikes the study committee provision of this bill. This amendment adds traditional and commercial driver's licenses to the data collection provisions of SB 96. And finally, this amendment changes the deadlines for law enforcement agencies to submit the data to the Police Standards and Training Council from January 31st to March 31st. This change allows more time for law enforcement to process the data. Now, the ethnic and racial category data collection provision of SB 96 was unanimously supported by members of the LEAC Commission. I will quote the findings of the LEAC Commission in their written report to Governor Sununu. The Commission makes the following recommendations for reforms and improvements with respect to the current state of relationships between law enforcement and the communities they serve. 1, data collection. All law enforcement agencies should gather, analyze, and make available to the public, at least annually, data on demographics, including at a minimum, gender and race, for arrest, citations, and motor vehicle and subject stops, regardless of disposition. 2, New Hampshire Department of Motor Vehicles should include a person's race on New Hampshire driver's licenses and non-driver's identification cards, with the option for the person to opt out from answering the question. All law enforcement agencies will comply with RSA 106-B:14-C by submitting crime reports to the Department of Safety Division of State Police based on the specifications prescribed by the Federal Bureau of Investigation. End quote. Now, this amendment strikes the study committee provision of SB 96. The Senate had replaced the demographic data collection with a study committee. There is no need for a study committee. It would be merely a platitudinous gesture to convene a study committee on this subject because the members of the LEAC committee spent hours thoroughly working on this. Now, transparency in government is the cornerstone of democracy. New Hampshire residents are entitled to full transparency about policy matters that affect our citizens. Please vote ought to pass on Amendment 1510. And in closing, I would like to say, Yogi Berra said, if you don't know where you are going, you will end up somewhere else. That is how I feel about the need for data collection. Thank you.
Thank you. Anyone else wish to comment on the proposed amendment? Yes, Representative Horgan.
Yes, just wanted to say, during the earlier debate, we had a number of law enforcement officials paint a rosy picture of the relationship between our law enforcement community and those they serve, and it certainly is better than other places. But we have the same problems. We have the same problems that every other part of the country does. So I think this data collection is necessary in order to. We don't, as I said, we don't know what the problem is if we don't know what the problem is. So probably Yogi Berra said it better. So I support this amendment too.
Representative Wolper.
Thank you, Mr. Chairman. Mr. Chairman, I generally oppose, and in this case oppose, the collection of race and ethnicity and other types of data such as that. I think that's totally against the way the American system works. We are supposed to be colorblind, and I don't think we need to gather data to find out that we're 97% white in New Hampshire. In addition to that, the idea of putting information on driver's license is just even worse. I don't know. What are you going to declare? I can declare myself to be anything I want, I guess, and put it on my driver's license. If you could find room, which I don't think we can because we've got it already so filled up with other things, that there is no place to put it on a driver's license and still have a real ID. So I'll be opposed to the amendment.
Yes, Representative Harshal.
Yes, thank you, Chair. I just had to speak when I heard that America is supposed to be colorblind. Yes, when we live up to our best principles. But I think right now we're trying to establish whether or not there is a problem. And because this is a voluntary program, it will give us hard information. A study committee is a delaying tactic and will mean nothing without getting hard data to support the, whether or not we are truly colorblind. I would love to believe that we are, but I think that we owe something to our citizens to really establish the facts of the matter. Thank you.
Anyone else wish to yes, Representative Di Lorenzo?
I could just respond to Representative Welper's comments on collecting the race data. That part of the program is entirely voluntary. When folks go to renew their driver's license, they would have the option of including the race and ethnicity data on the license. So it's not an enforced, rule by the state. So, it's totally optional. Thank you.
Representative Alexander.
Thank you, Mr. Chair. Thank you, Representative Di Lorenzo, for introducing this amendment. I just think it's important to point out that the LEAC Commission, although a great commission, did a lot of good work. There were no legislators on that commission. So I think that having a study committee might be a good idea so that we have clear separation of powers, so that we do have people that are studying this in another branch of government. So unfortunately, I have to vote to oppose the amendment, not oppose the idea.
Representative Birch?
Changed my mind, not going to ask the question.
Anyone else wish to comment? Representative Simpson.
Just real quickly, I want to say that the LEAC Commission did not have legislators, but it had very many highly respected experts in fields of a broad, diverse array of stakeholders who are very informed on these issues and the best way to get to reform. And they work towards consensus within their group, which represents the citizens and the residents of the Granite State. So I just want to say that I trust them on this, and I would like to support this amendment so that we can get the language back in there that will move us closer to where we want to be as a state.
And any other comments?
Mr. Chair?
Yes, Representative Di Lorenzo.
I'd like to respond to Representative Alexander's suggestion of a study committee. A study committee is going to be nothing less than a delaying tactic. The recommendations by the LEAC committee were done in real time, and we need to respond in real time so that we can get this program off the ground. So I would be very disappointed to see a study committee formed on the race and ethnicity data collection part of the bill. Thank you.
Anyone else? Seeing no one, we're going to be voting on Amendment 2021-1510H. Mr. Clerk, do you want to call the roll?
On the adoption of Amendment 1510H, Representative McLean.
No.
Representative Sylvia.
No.
Clerk votes no. Representative Alexander.
No.
Representative Melvin.
No.
Representative Murner.
No.
Representative Green. No. Representative Kelly.
No.
Representative Rizzuto. No. Representative Trotter.
No.
Representative Smith.
Yes.
Representative Burke.
Yes.
Representative Horgan.
Yes.
Representative Di Lorenzo.
Yes.
Representative Rogers.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Marshall. Representative Marshall.
Sorry. Yes, definitively.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
No.
I vote 10 in the affirmative, 11 in the negative.
The amendment's been defeated. Open to further amendment. Representative Alexander, did you have an amendment?
I do, Mr. Chair. I move amendment, 1391. And looking for a second.
Seconded, moved by Representative Alexander, seconded by Representative Murner.
So I forwarded Amendment 1391 to the committee last week. Essentially, Amendment 1391 would simply remove Section 9 of SB 96. Section 9 addresses the training covering implicit bias and racial profiling. The language in Section 9 states that, quote, the Chief Justice of the Supreme Court, in consultation with the Chief Justice of the Superior Court and the Administrative Judge of the Circuit Court, shall encourage all judges to take training every year. Upon doing some research, according to the code, the U.S. Code of Conduct for Judges, a judge should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. A judge should not allow family, social, political, financial, or other relationships to influence judicial conduct or judgment. So in order to be a judge, basically, you have to be unbiased. This language was amended in the Senate upon looking back from the mandatory 2-hour training every year to the language encouraging training. So I just get concerned anytime the legislative branch gets involved in some of the affairs of the judicial system. This language basically holds no teeth. So I'm introducing an amendment just so it doesn't clutter up the RSA to get rid of this part of it. Thank you.
What? Yes, Representative Sylvia.
Thank you, Mr. Chair. I agree with this amendment. I think it's been pretty common practice in the Judiciary Committee to recognize the separation of powers and that putting in statute commands to the judiciary is something we're proud about, and especially as this is in its current form, it's just a suggestion. It's really a section of code, and our books are already rather voluminous. I only wish that the court would respect some of the legislation that we put forward, and not try and tell us what to do. But I think, at least in our case, we should agree to the bargain and control what they do. We don't actually have to listen to what they have to say.
Representative Simpson.
Thank you, Mr. Chair. I was unable to hear Representative Sylvia. It was muffled on the Zoom. I don't know if that was the case for everyone. I'm sorry.
Move the microphone over there.
Thank you. I hate to make you repeat yourself. Thank you.
Just briefly, I support this amendment. I think that this committee has a pretty strong tradition of recognizing the separation of powers, and further, this statute, as it's written in currently, is only a recommendation to the court, and therefore it's nothing more than a House resolution, I suppose, in terms of whether probably a joint resolution. And it just doesn't belong in our statutes. So I'll leave it there, and those are the highlights.
Did you hear that okay?
Thank you.
Any other comments? If there are no other comments, then this is on Amendment 2021-1391H. And Mr. Clerk, could you call the roll?
On the adoption of Amendment 13918, Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes yes. Representative Alexander.
Yes.
Representative Melvin.
Yes.
Representative Murner.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Anzulo.
Yes.
Representative Troyer.
Yes.
Representative Smith.
No.
Representative Burke.
No.
Representative Oregon,
No.
Representative Di Lorenzo,
No.
Representative Rogers,
No.
Representative Kenny,
No.
Representative Langley,
No.
Representative Partial,
No.
Representative Page,
No.
Representative Simpson,
No.
Mr. Chair,
Yes.
I have 11 in the affirmative, 10 in the negative.
11 to 10, you adopted Amendment 1391H, right? We're now open to further amendment. Are there any further amendments? Representative Alexander, would you like to make a motion?
Sure, Mr. Chair, thank you. I'd like to move ought to pass as amended on SB 96, and that's with amendment number 1391.
Seconded and moved by Representative Alexander and seconded by Representative McLean that this committee recommend ought to pass with the amendment 1391. Discussion? Representative Ovian.
Thank you, Mr. Chairman. So I think the OLEAC report was a good place to start. I think this bill now is missing something that's would be an important piece to it, so I will be opposed.
Any other comments or questions? Seeing none, this is on the motion of ought to pass as amended on Senate Bill 96. Clerk, you want to call the roll?
On the adoption, SB 96 ought to pass. Representative McLean,
Yes.
Representative Sylvia,
No.
clerk votes yes. Representative Alexander,
Yes.
Representative Melvin,
Yes.
Representative Murner,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Rizzuto,
Yes.
Representative Troyer,
Yes.
Representative Smith,
Yes.
Representative Burke,
Yes.
Representative Oregon,
Yes.
Representative Di Lorenzo,
Yes.
Representative Rogers,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Marshall,
Yes.
Representative Page,
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have 20 in the affirmative, 1 in the negative.
You've adopted the recommendation of ought to pass as amended. Does anybody have an objection? Going on the consent calendar? Seeing no objection, we'll put it on the consent calendar. And is there any other business that needs to come before the committee today? That completes our hearings. And with regard to the report, Representative Alexander, when do you think you can get that to me?
I will take care of that by the end of the day.
Thank you very much. And you're not doing the minority report, or you are?
For something on consent.
Okay. Okay. Any other business to come before the committee? Seeing none. Thank you very much. And we don't have any further committee business at this point in time, so we'll be, I guess we meet at the call of the chairs. Take care, everybody.
Thank you.
Thank you, Mr. Chairman.
Thank you,
Thank
Mr.
you.
Chairman.
Take care.
Thank you.